I mean, whoa.
Great.
Come on up. Wow.
I love the jacket.
Wow.
Love
In the flesh. It's been so long. How are you? Good morning, Ms. Furlow. Ma'am, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. Okay. Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated they were in their car and backing out of their driveway when the defendant parked behind them. The defendant then got out of her car and started banging on the complainant's vehicle while shouting obscenities and threats. The defendant also tried to gain entry into the complainant's vehicle. Specifically, the defendant stated she was going to whoop their ass, and the complainant stated they were in fear for their lives during the incident. The officers discovered the defendant is a coworker of one of the complainant's family members.
Owner, boss.
So the threat is what?
The threat is she was banging on the door and said, "I'll whoop your ass."
I have it on camera.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons, okay?
Hired.
What do you do for a living, ma'am?
I own a fleet company, 3 trucks, and they're my drivers for the road, my OTR drivers.
Okay,
So they just basically stole my vehicles.
we are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, okay?
Okay, but I move out of state next month, so I just talked to my.
We'll have you sign a reset, and then we'll just take a seat while we get your bond conditions. We'll have you sign the bond conditions, and then you'll be free to go. Okay, please. You were Jalen Washington. Mr. Washington, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 7th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it driving with an expired registration as of July 2024 and failing to maintain a single lane, with both left tires crossing over the white marked lanes and the defendant's vehicle failing to signal a lane change. The defendant was the driver of the motor vehicle, and upon contact, the officer observed him with a strong odor of an alcoholic beverage, glossy eyes, swayed balance, slurred speech, and the defendant was slow to answer questions at times. The defendant admitted to drinking, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read, and the defendant consented to breath. The results were 0.106 and 0.106.
Mr. Washington, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living?
Currently, I work at FedEx, but I'm in college.
You're currently enrolled in college? Great. Where do you go?
PV. Sorry.
Okay. What are you studying?
Architecture, civil engineering.
Fantastic. Great. It's a big hiccup, man. This can really affect you. You know, anytime you want to get licensed to be an architect, you got to be licensed. All this. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're not allowed to smoke any marijuana. I'm going to test you. If I find that you continue to use, I'm going to put you in jail. Do you understand? I'm not asking much. I'm just asking to stay clean. That's it. Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Sir. But I don't have a vehicle.
Do you see if he has a license? Any prior DWIs as well?
There are no priors, Your Honor. I'll run his license right now.
You don't have insurance in your name, then you're not allowed to drive any vehicle. You have to have insurance for, I don't care what car you're driving, unless you have insurance on whatever car you're driving, then you may not drive. And don't come up here and tell me, well, the car has insurance. No, people get insured. Do you understand?
Your Honor, he's eligible.
Okay. Did you want to apply for an appointed lawyer? You're going to go hire a lawyer? Okay. If you have any issues, if you want me to appoint your lawyer, just come back, tell me, and I'm happy to do it. You know, I mean, money that you have, I'd rather you spend it on school. Are you sure? You don't want an appointed lawyer?
I'll make a phone call to you. Yes,
Okay. Got to understand that if you're going to hire a lawyer, there's a lot of timing requirements with the DWI. Don't sit and wait a month, 2 months, 3 weeks because you're hurting yourself. Got to do it like lickety split. Do you understand? Okay, like I said, you ever have any issues, come back, talk to us, and we can appoint your lawyer, okay? For sure. So I'll have you sign a receipt, Victoria. We'll have you get with Felicia for your bond conditions. If you have a change of heart, just come back,
Yes, sir.
you know? Okay. Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40-mile-per-hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
Consuming while driving?
there were 2 open cans in the cup holders, yes, Your Honor. And DICs were read and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you consume alcohol, illegal drugs, unprescribed controlled medication, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, Alex?
No, Your Honor.
Any prior criminal history at all?
She has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free? Why?
I just graduated nursing school, so I was a CNA and caregiver for in an independent care facility. But right now I help take care of my great grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive, any source of income that you have, money in the bank, stocks, bonds, IRAs. I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it. You understand? Okay. Do you mind giving me an application, please? Morning, Mr. Singleton.
Good morning, sir. How are you?
Doing great. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So
See, you have the decorations.
thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but you know, my concern, and I guess my very, very primary concern, is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around 200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us. Our bond is set at 5,002. What did you guys want?
Possibly looking for a PR bond, due to the fact that his other 2 cases are extremely high. We believe that he should be able to bond out on that. We have been talks, he has been in talks with some family members regarding possibly coming up with money for the other 2 bonds, but reducing it here would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is, it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they,
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
So there's two complaining witnesses on those cases, Judge. And it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with a deadly weapon, Judge, so in the felony cases, there's two weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
At them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some, right? So,
So the state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
even if it's not, going totally to a PR, if possible to do 2,500, that was great.
I don't know, you know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now two aggravated assault cases where in one, you point a gun at someone.
Shoot them in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But Mr. Singleton,
Not that.
there's a certain way when someone takes something from you. There's a certain way that you got to act.
I'm the one that
No.
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you.
Washington?
Refresh my memory because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver his truck when he was awoken by the defendant knocking on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant one, and then in complainant two, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We let you out, and then you pick up these two serious cases. You know, if we give you a PR bond now, if we were to lower it, I mean, what's going to happen? You're going to pick up a fourth case? We're trying to prevent that from happening, you know?
Order
in the court.
May I speak?
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
I understand, Your Honor. But I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow. No weapons, no contact with the complaining witnesses. And so here we are with two very serious cases. If you're able to bond out, and if you have someone, come back, talk, perhaps we can,
My fiance,
you know, but
the person who this is.
you're your own worst enemy, Mr. Singleton, really. I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
Yes.
sometimes choices are made such that,
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I understand.
You got to recognize it before the fact, before it balloons out of control. That's why, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, you got to try to take care of this beforehand. Now, why don't we have him TRAS'd? Okay, let's see what it says. Let's see how to go forward. If they say that there's treatment that's, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward. Okay?
Yeah.
Look, this isn't the be all end all, but let's see how we go forward. That's why God put eyes in the front. So we go forward. We don't go backwards. All right?
Your Honor.
Okay. All right.
Thank you. Appreciate it.
Stay. Okay?
When the machine is wrong, who pays the price? One of the most legally fascinating moments in today's courtroom involved not a dramatic confession or a shocking crime, but a piece of technology. A Scram ankle monitor reported that a defendant tested positive for alcohol at 12:42 in the afternoon. 5 minutes later, at 12:47, the same defendant tested negative at the courthouse. The judge stopped everything and said what every American with a basic sense of fairness instinctively feels. If that machine is wrong, I am not going to punish someone for something they may not have done. Under the 14th Amendment's guarantee of due process, no American can be deprived of their liberty without reliable evidence. But here is the question that today's docket forces us to confront. As our justice system relies more and more on electronic monitoring devices, breathalyzers, Scram monitors, GPS ankle trackers, and interlock systems to supervise defendants in the community, what happens when those machines malfunction, and who bears the burden of proving that the technology failed rather than the person? Because in a courtroom, a false positive is not just a software error. It is someone's freedom on the line.
Alan, depending on what that TRAS says, it may also help with what upstairs to try to work out some kind of treatment program so that, because it's all just anger, right? Yeah.
That's the first time I've seen it actually. Like that, so it may be something.
It may be worth exploring because it'll help, hopefully upstairs as well. Yeah, thanks. Yes. Mr. He?
Yes, sir.
Good morning, Mr. He. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Okay.
On November 11th, 2024, officers conducted a traffic stop for a defective license plate lamp in Harris County, Texas. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed a strong odor of an alcoholic beverage, watery bloodshot eyes, and disorientation. Standard field sobriety tests were administered. HGN 4 out of 6. Walk and turn and one leg stand were not administered due to the defendant becoming belligerent. Walk and turn, prior to termination, they had detected 1 of 8 clues. The defendant read the DIC and refused to provide a specimen. A blood search warrant was obtained and executed.
Any prior DWIs?
No, Your Honor.
Okay. Mr. He, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If we find that you consume alcohol or drugs, you will go to jail. And that's it. Do you understand? Do you have a valid Texas driver license? Do you have valid liability insurance in your name? You may continue to drive as long as you have both, and Mr. Murphy will tell you if it does become suspended. If it becomes suspended, you may not drive. Now, because you have a lawyer, we will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with Mr. Murphy, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're gone and you're not responding, I will issue a warrant for your arrest.
That won't be an issue, Your Honor.
I don't think it will, but we have to put you on notice of what we expect and what, what happens when you start acting up. So we will have you just sign a reset with Victoria. We'll have you get with Felicia for your bond conditions, and then you guys are free to go. Okay?
Judge, thank you very much.
Guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, You're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only do you pick up 1 DWI third, but you pick up a second DWI third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11/7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You picked up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday, which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock. At 11 a.m., they got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that that machine's integrity is not correct. So if the integrity of, and he's maintained that he has not been drinking either time. Every time we leave the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering in alcohol, then he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does, every case, every probable cause, I don't think I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well as people with charges, right?
And Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that.
So he takes a urine sample. It looks like on 11. What day was it?
11/7.
11/7.
I think the sample was taken around noon. He did 2 that day, 1 upstairs and 1 downstairs. So 11 and 1 o'clock, he had to do 2 different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have 2 urine analysis around the same time as that he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah, so it's probably not in those records because right now it's just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be.
What time was the positive for alcohol on 11/7?
For the scram report? Let me see.
I thought it was like 11 a.m.
Sorry, normally I don't look over those reports because I don't know how to use them, but I will try to figure it out.
And Judge, I might have an unupdated report. The only BVR I have here is for a scram violation from October 30th.
Yes.
Was there another violation?
Yeah.
Okay.
So there's a violation technically pending on our end because he was coming in that day, so I addressed the violation. And so they were waiting to file it to see if judge wanted that to be filed because he was going to address it at court. And that's what we're discussing from 11/7. So that violation is pending a DVR because judge is taking action on it already.
Do we have a,
I could have sworn you said that there's another presumptive alcohol
On 11/7.
on 11/7.
No, there's a presumptive negative for the POC test that he took, our rapid test.
No, yeah, right.
On
I know that one.
11/7, it was a alcohol detected, but. can't
What
be
time was that?
confirmed. I'm trying to read the report.
Because
but I can't remember
that's,
the
we've got a.
So I got it right here from Brittany Gordon. The defendant order was to obtain a scram device. The defendant's scram device has confirmed one tamper event. The tamper event occurred at 11/7 at 12:42 p.m. Now he was taking the test at 12:30
Hold
p.m.
on. Saying it was 11/7.
At 12:42 p.m. Got this email on November 11th. It went to everybody in the court. And alcohol was detected during the tamper. However, alcohol cannot be confirmed as consumption because of the nature of the tamper.
It began at 2:25 p.m. and returned to baseline at 8:04 p.m.
We also took another test with you guys on 11/7.
Yes, that was at 12:47, I believe. Let me double check.
What? So at 12:42, he tests positive for alcohol, and then at 12:47, he tests negative for alcohol. Am I right?
It was, sorry, one second. It was Tuesday, October 20th. I'm sorry, Judge, respectfully, I have no idea how to read scram results and everything that's in my email, but I can check on the drug test for you.
Well, so the 11/7, we got the email on November 11th, okay? Then if you go to the email she just sent me, it tells you when the lab test was submitted. Hold on. You just sent me this email. In this email from Average Size Individual Screening Report, on 11/7, it says that it was, one of the collection times was at 12:08 p.m. on 11/7, 12:24. He did negative. So that means while he was in court, he would have to drink. But then he took another test after that. I don't know what the other test is at. What I'm saying, Judge, I'm just saying this whole, if we were in trial right now, the whole integrity of these machines would be in question right now, because in the previous test, because the same exact message that we got on 11/7 was the same exact message that we got on 10/29. Scram tamper, alcohol cannot be confirmed, same thing. So what I'm saying at this point, he has maintained to me, and I know he's messed up numerous times. He's maintained to me that he has not touched alcohol since his last situation. He did drive. He's wrong for that. But these new testing procedures that he's got, Huh?
I mean, he did
That's
drive.
that's why we're in here, because he was driving,
So due to the charge though.
yeah, he did drive.
I hope to God that you're not driving this drunk.
No, I'm talking about due to discharge, while we're back in your court.
Okay.
Judge, I don't have any of those emails. I think the best thing at this point is we can set this off for a bond hearing, and I can bring Ronald Grant here to clarify all of this with all of us, because none of us are experts. We don't know how to read the report. I know what defense is saying, but I can't even tell you the veracity of anything that's happening because I don't even have these emails.
Yeah, so
I can subpoena Ronald Grant. We can do this next week. I can get it done.
let's not disrupt other people's lives. It's not necessary.
Sure.
He is saying that we have a test, and I mean, what Mr. Evans is test 11/7, the scram at 12:42, there's a positive, but then 7 minutes later, there's a negative when he goes up there to test. The machine's obviously messed up if that's true.
Is that what you're saying, Felicia?
And then I've also noticed on the scram report, I asked them, because again, myself, I cannot acquire this, I have to have it provided from our case managers and the provider of the device. But the scram report, the only one that I'm seeing attached to the email is for the DVR that was filed for the 29th, but I'm not seeing the one from 11/7.
So we don't have a scram report from 11/7.
We have an
It's
email.
not attached in the email, but we do have the rapid test when he was on site.
The rapid's negative.
Yes, and then we were informed, like I informed you yesterday, of the pending BVR violation for the 11/7 at that time.
Hold on. So, Judge, we don't even have the scram report. We don't know what the presumed blood alcohol content was. It's very possible that if he had a very low blood alcohol content or breath alcohol content, that the scram detected that he could have come to court, taken a test and gotten a presumptive negative because it's already been eliminated from his system. That's why I'm saying I believe we need to get that scram report from 11/7, get what the tamper is, have Ronald come up here and tell you what's possible or what's not possible, because he's the expert, and I get what defense is saying, but he doesn't know either.
But
I don't think-
let me respond to that. What we do have is a test that happened at 12:07.
Right.
And I can show you that one. So even if we don't have the one that she spoke of at 12:47 that she referred to, we have a test right here, which will make us have to believe that while in court, he drank some alcohol if these machines are deemed to be valid. And we were about to reprimand him for the 11/7 situation, but now it's time to.
Reprimanding or remanding, or he's suggesting that we just do it at a later time to get everything all together.
Okay, well, in the meantime, since these machines,
I'm not gonna take him into custody until I know 100%.
but can we, because he's working, he's come up here. The reason why you put him on Monday, Thursday is because these tamper going down. So we're gonna wait to see if these machines are valid. I'm requesting that we go back to the same bond conditions that we had prior to the tampering. So he does not have to miss work twice a week, coming out here and testing, because all we know, this could be a big mistake.
And I would strongly object to that, Judge, based off what he's on probation for right now.
But the only reason why we're doing the twice testing is because of the tampering. So if the tamperings are invalid, why are we doing something extra when that wasn't what the judge originally wanted?
Well, because there's an allegation right now. We need time to confirm or deny that. But for now, the safety of the community warrants these bond conditions, in my opinion, Judge.
And I strongly disagree.
Mr. Evans, we have a curfew on, right?
I don't think we have a curfew. We just have the scram. You just have
He
the
has a
scram.
curfew, Judge.
Yeah.
Well,
So,
okay.
so,
Are you working now?
yes, sir. Working with a hospital I have a project with Epic. So I assist physician and nurses on the software they use called Epic. The software is called Epic.
I don't want anyone to lose a job. I mean, the last thing I want is someone to lose a job, right? But I have to know that you're not drinking. I can tell. I know that you tell me no, but all I have are consistent problems. Every time we had you on docket for whatever it may be, there was always problems. Every single time you came in here with the DWI, there were issues. Every time you came in here with the suspended license. And I'm telling you the history that we have,
Understand.
you know?
Understand.
So that's why it's hard to believe all these coincidences when the nature of my relationship with him was every time he had a case, there was at least 3 BVRs, every single.
And I was on your, I was completely on your side. I thought he was telling me not the truth. But once I saw that he was in court that day.
Let's do this. Let's set it for next week. Let's
Okay.
get every record, subpoena the person, right?
Can we do next Friday, Judge? Is that possible? I'll be in trial next week till about Wednesday. Can we do next Friday? Okay,
Or not Friday, Thursday? Or, okay,
Friday's okay. Yes, Judge.
yeah, and do you want me to waive the appearance?
Can we, I just want you to waive the test.
Oh, okay, I will.
Yeah.
I will.
Yeah, that's all I want.
He's got to be here for the next BVR here.
No, yeah, that's fine. Yeah, I just want him to be able to work. So thank you so much.
I'm tired of having to deal with one problem or the other. I would suggest that you go now, go get a new machine so that we know that there are no more issues. Go down there, tell them, hey man, give me a new machine so that we know if there are any issues, that way you can make sure that you get a new one. Felicia, can we send him for a new one now?
Yes.
Just to make sure that, Okay, so you guys pick it, we'll do it. And then we'll do it. We'll take them off
Thank
that.
Thank y'all.
We'll stop for now. Yeah.
So you send me the test upstairs, right?
Okay, Connor. Okay.
Salazar, Your Honor.
Good morning, Mr. Salazar. How are you?
No good. How about yourself?
Friday Eve. So,
Got everything worked, worked the felony out, Judge. He pled guilty to the felon. I believe they reduced it to a lesser included. Reduced it to a misdemeanor.
Oh, they did?
Yeah, and,
Okay, so it's not a felony. Good.
but they're deported. They've already, got the deportation orders in on it.
Really?
Yes, sir.
Yeah. These are things that you got to think about, man. When you're not in this country with permission, you have to think about these things, because when you start acting like a fool out there, they can put you in immigration custody, and then you're stuck like Chuck and then they'll end up, sending you back. What's going to happen now? Is it from Mexico or is it?
Yeah. Yes, sir.
Yes, sir.
So do you have family there? At least when you get there, that,
Yes, I do.
okay, well, that's good.
Yeah.
The only thing I'm gonna tell you is that if you want to come back here, do it the right way. You gotta ask for permission first. Don't just come here. Because if you get caught with the feds, you could be looking at serious time in federal custody. Years and years. Don't just come. Do things the right way. And when you do that way in life, good things happen, So what are we doing here?
We're pleading true to the, MRP violation, Judge.
In essence, I mean, there's nothing we can really do anyways, because you got the ice hold, so it's,
We had 40 days before they come pick him up.
all right. Did you agreed to voluntary departure? Is that what happened?
Yes, sir.
Yeah, okay. All right, so Mr. Salazar, you were placed on probation for assault of is it a family member, right?
That's correct, Judge.
So there is an affirmative finding.
Yes, sir.
You have to understand that you can never own a gun or ammunition as a result of this. There's an affirmative finding of family violence. So if you ever pick up another one of these cases, you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. A second assault of a family member is a third-degree felony. Do you understand? The other thing you need to understand is that you now have had already a felony reduced to a misdemeanor. The likelihood of them doing that again, it's like lightning striking twice. You understand? Is it true or untrue that you violated your probation?
True.
I will find that it's true. Let's do that on allegation number 15, that he tested positive
Yes, sir, Your Honor.
not on the
Law violation.
law violation.
Yes, sir.
All right, I'm going to find that is true, Mr. Salazar. I'm going to sentence you to 90 days in jail. I'll give you credit for the 78 days that you've done. Like I said, there's an affirmative finding of family violence. You can never own a gun or ammunition as a result of this. Just be careful, man. You know, if you want to come back, do it the right way. Ask for permission first. All right? Good luck.
Thank you.
Thank you, Mr. Dean.
Yes, sir.
All right. Anderson, tell me about Mr. Anderson.
So there is a bond violation, and
Come up, Mr. Anderson.
however, we worked out a deal with the state,
What?
and to reduce it to a first and then 12 months probation.
Okay.
We have the plea paperwork in your,
Are we doing that now?
if you'll allow us.
Sure.
Okay.
Is this a foregone conclusion that you're going to go into rehab, Mr. Anderson?
Yes, sir.
Because I'm going to tell you now, this is now makes 3 bond violations. The next time you even go next to alcohol, I'm going to put you in a rehab facility.
Yes, sir.
Understand me. I don't care what you're doing. I don't care what it is. You come here kicking and screaming. If I find that you use while you're on this probation, I will amend conditions to put you in a rehab facility. And you could be in there for a very solid year, depending on how well you respond to treatment. You understand?
Yes, sir.
Okay? It's up to you. If you want to do it, I'm game.
That's his decision.
It's up to him.
Sir.
Okay, done. Do it.
We need to do the.
Are you, I'm sorry, are you ready to go? Okay. Mr. Anderson, you charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement that they're offering you 180 days in jail to be probated for 1 year. As part of the conditions, you will do a DWI repeat offender. It must be a repeat offender DWI education class, okay? 1 victim impact panel, a TRAS to see what other conditions you may need. You must fulfill those conditions while you're on this probation. No breath test refusal. So if you're pulled over in a car and an officer asks you to submit to a breath test, you must take the breath test. No drugs, no alcohol, guardian interlock, 16 hours of community service. Do you have children, Mr. Anderson? What does he have on now? Does he have on a guardian interlock? What does he
He has
have?
a scram right now.
Okay, I'm going to keep that on for now because I'm suspending his license for a year and I want to make sure that he's not consuming alcohol at all.
So you want him to have the scram and the interlock?
And that's with the franchise, so it'll have to be taken off and then new one will have to be put on from.
Okay, I don't want to take this off until he puts the other one on though.
And Judge, just a reminder, this is a drug. I don't know if that changes your
No,
decisions.
I have here that he consumed alcohol. So he's still using. I don't care how minute any alcohol that you have, Mr. Anderson. I'm telling you, you consume even a smidgen of alcohol, you will be looking at a motion to revoke that gets filed, and then you will be perhaps and very possibly looking at a rehab facility in the jail. Do you understand? I would like him TRAS'd today. Since he's here today, he gets the TRAS today. And in the TRAS, I wanted to make it known that he has, this is his 3rd bond violation, and that he has a consumption of alcohol 3 days ago, because I want that part of their analysis and how to move forward. So what part of what you are agreeing is that you are agreeing to whatever conditions. What conditions are being done by the TRAS? So I don't know what they're going to assess. They may assess intensive outpatient treatment. They may assess supportive outpatient treatment. They may assess something else. Whatever they assess, you must fulfill those conditions. Do you understand? The other thing that you must understand is that even though they're reducing this to a first, and the reason that they're reducing this to a first is to a first DWI is to bypass the mandatory 5 days in jail. That's why this is happening now. But I want you to understand that for the next 70 years of your life, you have all these charges on your record. So if you get pulled over from now on, even the slightest smell of alcohol, you will be in felony court looking at a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand?
Sir.
So I wouldn't even step near a car if you've had something to consume or if you've had any alcohol whatsoever. Even if you take too much NyQuil, that will cause a loss of the normal use. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? How do you plead to the second offense, DWI, being reduced to a first? Guilty or not guilty?
Guilty. Guilty.
Is it above a 0.15? Is this above a 0.15? Morgan? Do you know?
No, Judge.
Sorry?
No, judges.
No? All right, I will find you guilty. I will send it to you the agreement. What do you do for a living, sir?
I build valves for oil rigs.
And how much money do you make a month?
About 2 a month, 2,000 a month,
How much do you really make a month?
25,
How much do you really make a month, sir?
2,500.
Order in the court.
I'm not going to assess court costs, but I don't know about assessing the surcharges. That's why I'm asking these questions.
The surcharge shouldn't be assessed on a probation. It's only on a final conviction.
This is a conviction.
It is a conviction, but
It is a conviction.
it's not for DPS. They don't consider it a final conviction because,
It is, though. It absolutely is. We're not doing a deferred.
right, it's a final conviction for the purposes of it being on his record forever, but not for the surcharge.
Okay, so I'm going to take a look at that now. I don't believe that that's the case because I'm going to issue the surcharge on him.
Okay.
Okay, if it's not, I mean, I'll take a look now after it dies down,
Okay,
but I don't think that's right. But, and, I mean, you'll be around, right?
yes.
Okay, give me a second. Let me thin out the line and then we'll talk. All right. Take a seat, or I'm going to have you sign all the paperwork.
Yes, sir.
Watch yourself, Mr. Anderson.
Yes, sir.
No tolerance. All right. Good luck.
Sit down.
There's an open container. That's a minimum of 3 days in jail. Did you want me to abandon the open container?
I'm okay with abandoning it, Judge.
Okay, all right.
So what's going on?
Maybe just-
I'll let you finish off, Your Honor. The defendant ended up calling us back later in the afternoon, but that was after.
Are you guys happy?
Yes, sir.
You want to withdraw it?
Yes, sir, I do.
Done.
Okay, perfect. Thank you.
Okay, for sure.
And Judge, before we're done, there's a companion case that's being dismissed as part of it.
Right, and I see that the gun case will be dismissed. Oh, what about the gun, though? Are you guys forfeiting the weapon?
I believe that was part of the agreement, yes.
Okay, the weapon will be forfeited. All right, it'll be
Order in the
coming.
court. It's
Do you want
getting
him
too loud.
do you want him to speak with probation?
Yes, please.
Judge, I just had a question. You want us to do grandma consume the theater?
Correct. Yes.
And then they can sign it.
Is it all right if I text one of our clients? You're about to talk.
Of course. Yeah, of course.
Judge, see my attorney, is it okay if she stands up here with us?
Sure.
Thank you, Judge.
Hi, how are you?
Good. How are you?
Welcome. Who do we have here?
We have Miguel Gonzalez, Your Honor.
Okay. Good morning, Mr. Gonzalez. Mr. Gonzalez, you were placed on probation for driving while intoxicated. It is now alleged that you have violated that probation, specifically in that, I guess we're not going to go forward on the Berg habit.
Correct. We agreed that we're going forward on the 3 technicals, not the first 2 new law violations.
Okay, I guess to make it easy, we'll just go forward on the failed to perform the community service hours as ordered. Is it true or untrue that you violated your probation?
True, Your Honor.
I will find that as true. I will now revoke your probation, sentence you to 75 days in jail. I will give you credit for the 8 days that you have done. Did I suspend the license?
It wasn't the first time?
Because when they get on probation, normally, unless it's a second, so was this a first?
It was originally filed as a second and pled down to a first.
No, you're saying I didn't?
You did it.
Okay, I have to now. I'm going to suspend your license for 180 days. Mr. Gonzalez, don't drive until you get a license. Otherwise, you get into a car, you're rolling probable cause, man. You understand?
Yes, sir.
Okay, good luck with you.
Thank
All
you,
right,
Judge.
thanks, guys.
Can I be excused?
Yes, ma'am. Thanks.
What today's docket gave us was a masterclass in the quiet, unglamorous, absolutely essential work of a justice system trying, sometimes imperfectly, always relentlessly, to get it right. We watched a college student studying architecture and structural engineering sit at that podium and hear a judge say, "This DWI is a big hiccup, and it could cost you your professional license before you ever earn it." We watched a nursing school graduate who cares for a grandmother with dementia be told she cannot drive and cannot drink because she was going 55 in a 40 zone with 2 open cans of twisted tea in her cup holders. We watched a man with 2 open felony aggravated assault cases, a machete in one hand, a gun pointed at a neighbor's head in the other, be offered a clinical evaluation instead of a slammed gavel, because a judge believed that anger untreated is a ticking clock, not a closed book. And we watched something that should make every American stop and think. A judge refused to revoke a man's bond based on electronic monitoring data that simply did not add up. Because in this country, technology does not get to replace evidence, and a machine does not get to decide guilt. The 14th Amendment promises due process. The 8th Amendment forbids excessive punishment. And somewhere between those 2 guarantees lives the hardest question any judge faces every single morning. How do I protect the public from this person while protecting this person from a system that is powerful enough to destroy them even when it is wrong? Today's docket did not answer that question. No docket ever fully does. But the fact that a judge is still asking it out loud on the record in front of everyone is exactly what justice is supposed to look like.
Yes, sir.
Mr. Arsenault, you are charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. It seems that probable cause has already been found in this case.
Yes, sir, Judge. I don't know why we're here, but,
Because he bonded out.
Oh, yes, sir.
I guess he's been AWOL, right?
No, sir, he's been in custody, Judge. He had a felony assault of a family member that was dismissed last week,
Okay,
and that's why he got out.
all right. So are there any kind of bond conditions that you guys would like state?
So for this one, just standard conditions would be fine with this type of case. And there's no contact for this.
Who's the complaining witness in the,
His mother. Judge.
His mother, Judge.
okay. Is that the complaining witness that was in the felony as well?
That's correct, Your Honor.
Okay, so I'm ordering you not to have contact with this person. Do you understand?
Judge, if I may, I provided the state with some information relative to that. The complaining witness in this case is not willing to go forward. She provided a letter to me, which I have already given to the state. She's requesting that the case be dismissed.
The state would not be opposed to no threatening or harassing contact at this time. And just give us another date to reset to look at the 911 phone calls to make sure that.
Okay, so the case is 180 days old. It's time. So we'll give you a
Okay.
week.
Yes, Judge.
So I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case and not to be in possession of weapons. If I find that you violate these conditions, I'm going to revoke your bond, put you in jail. Do you understand? I'm not asking for much. Now, your case is old. It's time to figure out what we're going to do. So I'm going to give the state a week to get everything done, wrapped up. They're going to put an offer on the case. The next time we come back, you must either accept the offer or I'm going to set your case for trial. Do you understand?
Yes, sir.
Okay. So do you mind filing those conditions, please?
Yes, Judge.
All right. We're going to have you sign the conditions. After that, we'll see you in a week. We'll go from
Thank
there.
you, Ron.
Okay. Thank you, Mr. D.
Yes, sir.
Hi. Good morning. Thank you for coming back. Did you run his license?
Yes, Judge. I'll run it right now.
Please. Mr. Venegas, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. I have previously found probable cause on this case. I'm ordering you now as a condition of your bond not to participate in like-kind activity. If I find that you're racing, reckless driving, acting a fool on the highway, number one, I'm going to revoke your bond, put you in jail. The second thing is I'm going to take away your privilege to drive. Do you understand?
Yes, Your Honor.
Do you see if he has a license?
Still running it, Your Honor. For some reason, slow.
Mr. Venegas, you are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a part of your bond conditions. If I catch you driving and you don't have a license or you don't have insurance, it's not going to go well for you here. Do you understand?
Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with him and he'll tell you when you have to come back. If he tells me he can't get a hold of you, then I'm going to issue for a warrant for your arrest. You pick up a new case, act a fool in the free world, I'm going to take it away.
I'm able to run it right now, Your Honor. It's not letting me on our system.
So can you file the same conditions on the racing that we
Same racing conditions, yes, Judge.
All right, so I'm gonna have you sign a reset. After that, we'll have you take a seat in the jury box. We'll get your bond conditions. We have you sign it, and after that, you'll be free to go.
Thank you, Judge Mack.
Please. Yes, sir. You are not allowed to drive. Do you understand? If I find that you pick up a new case or another third case, I'm going to go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that the next time I test you and you test positive, it's just not going to go well for you. You understand? We've given you a lawyer. There's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really.
And Judge, we're working on it. We have a out-of-state fine or suspension, but we cannot figure out what state it comes from at the moment. So we
Call
are working.
DPS, you know.
Because they're even
You
when they
can
run.
call DPS. Have I given you the phone number?
I don't think so, did I?
Hold on.
I think it's in Jacksonville.
Do you mind giving this to me? This is the number to the driver's license division for DPS. When you call, you have to call at 7 o'clock in the morning. Do not call at 8. Do not call at 9, 102, because you'll never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm gonna have you come up here, promise to us that you're not gonna drive, then I'll get you to Victoria, sign a reset. You'll get with Felicia if your bond conditions, and after that, you're ready to go. All right, good luck, guys. You got it. Are you Sherry Johnson? Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone. and the defendant was advised about the husband's request for report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to the husband cussing and pushed reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her, he merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
I never admitted it.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just. So what I'm going to do is I'm going to have you sign a receipt of Victoria. I will have you then take a seat in the jury box. I'm going to find you a lawyer, and then you can explain your side to the lawyer. Okay? Let me see one thing real quick. I need you to fill an application for me, though. Do you mind? She's going to give you an application. I need you to fill it out, and then I'll have you talk to someone here momentarily. No. Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The officer met with the complainant, the Walmart Asset Protection employee, and the complainant stated that he reviewed store surveillance, and on September 12, 2023, the complainant observed the defendant open the register multiple times, take cash, and place the cash into pocket, a total of $790.41. On September 13, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02, and on September 18, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find your lawyer, ma'am. Miss Carolyn Price, ma'am, you were charged with assault. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer arrived at the complainant's apartment due to a disturbance call, and the complainant asked the defendant to leave her apartment after a verbal argument. The child was present, and the defendant then pushed the complainant, leading to further argument. The defendant, instead of the complainant, landed at least one with her right hand. which were also holding a pair of keys. The keys scratched the complainant's face, leaving red marks. The complainant then held the defendant on the floor to stop her from punching her until she calmed down, at which time the defendant proceeded to spit in the complainant's face. The complainant then let the defendant up and told her to leave. The complainant stated her pain level was about a 3 out of 10, and the officer observed the complainant to have 2 red scratches on her cheek.
Is the complaining witness to Ms. Price, please?
Your Honor, the complaining witness is mother of the grandchild, mother of her grandson.
Ms. Price, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you not to have contact with this person. I'm also ordering you not to be in possession of weapons as well. Did you need a lawyer today? Ma'am? Okay, I will appoint you a lawyer. For now, I'll have you sign a receipt. Victoria will have you take your seat in the jury box. Do not leave until you sign our bond conditions, and then I'll have you speak to the lawyer here. Okay, please. So you can file the standard conditions.
Yes, Judge.
Yes, thank you. Good morning, ma'am.
I do have a lawyer, but he's not here yet.
Who's your lawyer?
Denuna, Chris Denuna.
Chris Denuna? Have you heard from Chris? So, yeah, I see that he has signed on to your case. If you would like, just go ahead, take a seat, and as soon as he gets here, we can do it. Okay, please.
Fill it out in the jury box.
Good morning, Mr. Butler. You are Ms. Tovar Martinez. Do you speak English?
Yes.
Okay, ma'am, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. In the one leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were 0.212 and 0.217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Did you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
We have no license on file.
You do not have a license to no driving. Do you understand? You will be signing an affidavit with me today, promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol, man. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm going to do is I'm going to have you go to Victoria, sign a reset. You will get with Felicia for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, man. Okay. See.
Right this way.
Good morning, Mr. Cornett. You have a lawyer today. Did you want to apply for a court-appointed lawyer? Okay. Do you mind giving him an application? All right. I'm going to give you an application for an appointed lawyer. Fill it out for me. And then we'll have you talk to someone here momentarily, sir. Please. Morning, Mr. Daniels. Do you have a lawyer today?
Sorry.
You want to apply for a court-appointed lawyer?
I just started working. I'm gonna give this second court. Have a lawyer next quarter.
I'm willing to give you a free one. Okay, it's up to you. If you have any problems, come back.
I just started working, so I'm saying.
Good job, man. Great. What are you doing?
Delivery, so. Third parties,
Get a trade, dude. Get a trade. Go like welding or something like this.
I got my forklift, it's hard finding jobs, it's hard, like, so I knew somebody that got me in with the delivery, so.
Good.
Yeah.
You know, the better you do, the higher you're gonna go. Anything in life, man. Put your heart into it. Your sky's the limit. Right. Okay. THA. All right, we got you, man. Good luck.
Okay, just sign it. All right, there's next.
So ma'am, it looks like your lawyer was involved in an accident this morning, so he's not going to be here. So what we'll do is we're going to do probable cause. After that, we'll just give you a normal reset. They called us to advise you to call the office and then you guys can get together with them. Okay. So ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes.
Okay.
On January 19th, 2025, the officer was dispatched to a target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where she only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Saldana, I'm going to find that there's probable cause to go forward with your case. Where is this from again?
Target.
Target. I'm ordering you as a condition of your bond. Target. Do you understand? If you violate this condition or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, man. So can you file that, please?
Yes, Judge.
I'm going to have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay? So Danuna was in an accident this morning, I guess. So he's not going to be here. So we'll just do a regular reset. Just do, I guess, 30, 45 days. And then she needs state's conditions. Mr. Acosta, do you have a lawyer today? Did you want to apply for a court-appointed lawyer?
Come on up.
I think I'm gonna find one myself.
Okay. I'll have you go to Victoria. We'll have you sign a reset and then we'll get you on your way then. THA on this gentleman. Okay, Mr. Acosta, please.
Costa?
What is your last name, sir?
Peter, señor?
It's 28.
Thanks. Mr. Perez, do you have a lawyer?
¿Tiene abogado? No, I haven't.
Did you want to apply for a court-appointed lawyer?
He says, I know what happened.
So I don't want you to say anything.
Usted diga.
You have a lot of valuable rights. And when you start talking, you will start putting your foot in your mouth. You need a lawyer to represent you in this case because it has far-reaching consequences. Do you understand? You need a lawyer. You can either hire one or you can apply for a court-appointed lawyer. So the decision is yours. What would you like to do?
¿Qué desea hacer? Apply for an attorney.
Okay. I will, Deputy will give you an application. I will take a look at it.
Y lo voy a revisar.
Please.
Abajito de cada cosa está en español. Llénalo enfrente y atrás. Judge, was that a financial affidavit for Perez?
Yes, ma'am.
Okay.
Did you get this? Who is this? What is your last name, sir?
Julio Hernandez.
What page was the last one?
Last one, Judge, is page 37. Lola Fernandez.
Got it. Mr. Uloa Hernandez, do you have a lawyer today?
No, no, no.
Did you want to apply for court-appointed lawyers, sir?
Señor? Yes.
Okay, we'll give you an application. I need to know everything about you, and then we'll see whether you qualify for a lawyer. Please.
All right. Paper?
Thank you so much, Blas. You need the cause numbers?
I'll get them from Victoria, all of them.
Okay.
Lots of, ask them to have a seat in the board box.
Approach on behalf of Chaston Blackburn. Regarding probable cause, I have issues with probable cause in this case, Your Honor.
Okay, let's do it. Alex, you ready?
So officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the roadway. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, the officers observed a moderate odor of alcoholic beverage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard filtered write-ins were conducted, HGN 4 out of 6, walk and trend 4 out of 8, one leg stand 2 out of 4. DICs were read and the defendant consented to breath. The results were .086 and .084.
Your Honor, when you turn on the video and it's between.
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle and before any investigation is done, he says, I'm charging her. This is prior to basically any field sobriety test being done. She didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch the video for 5 minutes, Your Honor.
No. That's in for a suppression hearing. This is a mere probable cause, right? So because I have to give them the ability to respond to your arguments. We can't do that in a probable cause. Like, you know what I mean? So if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss, but if you lose, you got to plead, right? Otherwise, we can set it. But, when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that, I have to give them the ability to respond to that. I can't just rule on it, whether, there was an actual traffic infraction, that's like probable cause or not, right? But when you start getting into the actual details, everything, I mean, that's for, either a suppression or for trial.
That's very
So ask them if they're good for, dispositive. That's something that you want to do. Let me see. It's only 60 days old, so you've got some time, I'm happy to do however, go forward with however you want to go forward, but for probable cause purposes, you're getting into argument, right? And I can't give them, I have to give them the ability to respond, Okay, sorry. Mr. Newley, hey.
How are you, sir?
No, man.
Fine. I'm trying to revisit a PC for Mr. Resendez Atimio.
Okay.
You want the cost number, Judge?
It's on docket today, right?
Yes, Judge.
I see it here. Okay. Okay.
Yes, Judge. So for Mr. Resendez, on October 8th, 2023, officers were dispatched to a crash on West Ham Houston Parkway, and upon arrival, the officers observed the defendant's truck stopped in a moving lane of traffic with a flat tire and fender damage. The defendant was standing outside the car, but admitted to driving and drinking that evening. The officer observed the defendant to have bloodshot eyes, glossy eyes, and a moderate odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 2 out of 8, one leg stand 0 out of 4. The defendant consented to giving a breath sample, and the results were 0.074 and 0.073.
And Your Honor, regarding that dispatch to a crash, we did request an accident report and then found out that this was just about the defendant's tire having been popped. There wasn't an accident report that we did in fact
Thank
find. It was a flat tire front fender damage, however.
That's where we are, Judge. Defendant had told me that as he was driving on the parkway, he had a pop on his tire in the middle of the road. So at that time, he has to stop and was trying to wait for the subsequent traffic to clear. And that is all. There was no accident, just like.
I know, but that's not that's not definitive, right? So what happens is a cop comes to investigate, right? And I guess that's when he sees. So there are several theories in the law, like community caretaking, right? Where an officer is just going to make sure that someone is okay, and when they arrive, they start seeing indicia of intoxication, and then they can, I guess, you know.
Yes. And the blood is out now, and it's not up to the legal limit of 0.08 2 times. So even if we find the average, we're still below par.
Right.
And that's where we are now. So when I spoke to her, she said, well, unless if the judge will not find a piece, but she's okay.
Yeah, I mean, I think, remember, this is just to go forward. Whether they're guilty beyond a reasonable doubt, that's something completely different. But, you know, taken as a totality by himself, it's not an accident, but the cop can, you know, come up and just look to see, hey, is everything okay? And then that's when he sees.
If you look at the totality of the circumstance, Judge, and anybody using the road, it could be a judge, it could be me, and you have a pop of your tire in the middle of the road, it's expected that you stop. And you have to wait to get clearance to park your car properly. So if somebody may have thought it was an accident, like they had assumed before, in this case, the state said within themselves it wasn't an accident.
There's nothing wrong with an officer just coming and riding up to a scene to assist someone. I don't think that there's anything wrong with that. And then when he goes to assist the person, he realizes, hey, there might be something else that's afoot here. And then that's when he begins the investigation, right? It's enough for PC, but it may not be enough for reasonable doubt, you know? There's a 0.07. I don't know what happens with the field sobriety test. Have him eval it for trial, you know? And perhaps and they'll see, let's set it.
Yes, Judge.
Let me see how old this is, Resendez. Oh my God, it's 477 days old. Oof.
Because they're waiting for the blood.
It took 2 years though. Yeah, he was gone for a year. So let's do this. Let's set up for a week. Will you eval it for trial to see, is this something that you can actually make? I mean, you know?
Yes, Judge, we'll eval it.
So let's set it for 1 week. Let me have them eval it. Can they make the case? You know, it's not about just convicting every single person. It's about doing justice, right? So let's see. There is enough just for probable cause, but let's see what they say about it. Okay?
Thank you, Judge.
Okay, thanks, Mr. Miller.
Here is something I want every one of you watching today to think about. We are now in Judge Fleischer's courtroom, and right away the cases remind you why this channel exists. Today we watched a man come back to court on 3 open cases: a terroristic threat against his own brother, a terroristic threat against a gym manager after his membership was canceled and he came back multiple times threatening to kill the complainant, and now a reckless driving charge. The judge looked at him and said, 95% of the people in that jail are there because of no self-control. Think before you act. And then he addressed something unusual. The defendant had asked to change his lawyer. The judge said, "This is not Burger King. You do not get your way." So here is the question. The Sixth Amendment guarantees every criminal defendant the right to counsel, but it does not guarantee the right to a specific lawyer or unlimited substitutions. When a defendant develops a pattern of picking up new cases, threatening people in the community, and now attempting to remove the lawyer assigned to help him, at what point does the constitutional right to counsel become a tool for delay rather than a shield for justice? The judge told him, "The lawyer I gave you will tell you things you do not like. That does not mean you get another one. Sometimes the most honest thing a lawyer does is tell you what you do not want to hear."
I mean, whoa. Come on up. Wow.
Love the jacket.
Wow.
Love
In the flesh. It's been so long. How are you?
Good. I had an opportunity to come here and I took it.
Great.
So, yeah.
Fantastic.
Judge, I have a client on a felony.
Okay.
It's a PACA first setting in the 339th. We were up there getting everything squared away. I wanted to let the court know that's why he was late here. But I also wanted to see if the court would be amenable to appointing my office on the misdemeanor. If that's
Absolutely.
appropriate.
Absolutely. But you said Zavata?
Hernandez. Francisco Hernandez.
Is today for us, is it a,
Today should be an arraignment for y'all.
yeah, let me see, Hernandez. It's Francisco?
Francisco.
Francisco Hernandez, come up.
And Judge, he's in high school, 17-year-old. That's why I wanted to make sure I came with him.
Absolutely. Happy to do it.
Thank you.
Good morning, Mr. Hernandez. Mr. Hernandez, you're charged with evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 19, 2025, at approximately 11:17 p.m., the officer was dispatched to a discharge of a firearm call on Tilbury Woods Lane. Multiple calls stated there were multiple gunshots in the area, and while servicing the area, the officers were flagged down by a citizen who stated she heard multiple gunshots and a green sedan sped off. Multiple citizens provided video footage, and the officer saw a vehicle that matched the description parked illegally in front of a residence on Moss Springs Court Road, and multiple males exited the vehicle. The officer then initiated a traffic stop, and the driver and passengers began evading on foot. Officer ran after all three males for 100 yards, and all were detained by the officer. The defendant and others admitted they saw emergency equipment and decided to evade on foot. Surveillance video showed the defendant throwing an AR pistol with no serial number in front of the residence, and surveillance video matched the defendant's clothing.
Saying our defendant here was seen throwing an AR?
Allow me to read the DIMS to confirm that it is.
Sure. They filed a tampering. Am I right in assuming that that's the serial number?
Yes, Judge, it is this defendant throwing the AR, and the firearm had no serial number. Yes.
How can you impute the tampering because it's a specific intent crime, right? Unless you have an admission or something like that, something that I have. But you know what? That's not even my forte. It's like we're doing the evading right here. So
Fighting upstairs, gonna
I
fight
gotcha.
down here too. So you can already expect my issues with this case already.
you know, you're 17, you're now starting your life. This is not a good way to start. You know, you only have two ways that you can go. You can go up or you can go down. Life doesn't get easier the older you get. It only gets more difficult. You get bigger, fatter, you lose hair. It doesn't get easier. And it starts with school. Stay in school. Don't hang with dogs. You're going to get fleas. Do you understand? Mr. Hernandez, you are not to smoke weed. You're not to use alcohol. And I'm making that a condition of your bond. I don't want you to have any possession of any weapons as well. Do you understand? If I find that you're in possession of a weapon, I'm going to revoke your bond. I'm going to put you in jail. You're going to finish school with me. You understand? Did they impose any other kind of restrictions up there as far as like curfew or anything like that?
They did not. At first, he had an ankle monitor with the curfew. I asked the court, they agreed to take it off. So his mother and him are gonna go after this court proceeding to get that removed.
Is mom here?
Mom is here outside with his younger sister.
Okay. Make good decisions, man. Once you start racking up convictions, I'm telling you, it's over. It's not going to get easier. You understand? We've given you a lawyer. It is your responsibility to stay in touch with her. She's great. She will help you out. If you're not listening to her, you take off. I can't find you. You pick up a new case. I'm going to put you in jail. No more PR bonds for you. Do you understand? One more thing. I will test you in about 45 to 50 days. And if I find that you're smoking weed, it's not going to go well for you. Do you understand? You will get tested. Be ready. So I don't care what you're doing. If you stop doing anything that you shouldn't be doing now, then you should be fined in 45 to 50 days. But if you continue to use, or if you smoke, it's not going to go well. You understand? Okay.
Thank you.
Thank you so much for coming. We got you. And then anything you need, whatever you need, just come back and we're happy to help.
Thank you, Judge. And just one thing real quick with the state. I know there's other people that were in this vehicle allegedly. Do you have any names for them? Can you,
I can see.
if I circle back around from you?
Oh, co-defendants? That's a good, because you know what?
Well, that's part of my issue with both of these cases.
And Your Honor, it does not appear there's any connected cases.
So I have,
So
yeah, that's my issue with the tampering. That's my issue with this case.
They got them all, right?
That's what they say.
Maybe just because of the surveillance shows allegedly one being thrown and that's why they only went after. Perhaps, I don't know. But
I won't fight everybody too crazy today, but probably the next day. Yeah.
I'm with you. You know, whatever you need, just
Thank you, Judge.
make good decisions. That's all we're asking you to do. All right? Okay,
you very
guys,
much.
thanks. You got it. So, Mr. Hernandez, do not leave because we need you to meet with pretrial, okay?
yeah, we have the OR, so
Okay, you have the order?
it should be, are you connected to the case? Are you attached?
Oh, I see it now.
Okay, perfect.
Okay, thank you so much.
Thank you.
Judge Comanche, how you plead guilty, not guilty, but he's not gonna find you guilty. He's gonna find you guilty, he's gonna place you on 15-month probation. Yes, sir, and no. How you plead guilty, not guilty. Yeah.
Good morning, Mr. Harris. Mr. Harris, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 15-month deferred. This is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. What you must understand, though, is there is an affirmative finding of family violence in this case, meaning that you ever pick up another one of these cases, you will be facing a third-degree felony, minimum of 2 years, maximum of 10 years in prison. Do you understand? For you to complete this successfully, you must do a Batters Intervention Prevention Program, a BIP class. This is tough because this class is you must do it once a week for 18 weeks. And if you fail to go 1 week, they're going to kick you out. You get kicked out. We issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. You're facing up to a year in jail. Do you understand? It's no joke. No alcohol, no drugs. You must do also what's called a TRAS, an evaluation, to see what other conditions you may need. If they assess other conditions, you have to fulfill them as well. Do you understand? No weapons, no harassing, threatening, abusive contact with Brittany Senegal and Chanel Clayton. Mr. Harris, I will make you a deal. If you get this done quickly, I will take you off in half the time. If you're nice to everybody, get your classes done quick, sign up as soon as you start getting this thing, I'll take you off in half the time. You can be done in this thing 7.5 to 8 months if you really kick butt. Be nice to everybody and just don't test positive. Do you understand? Like I said, if you violate this thing, I'm going to issue a warrant for your arrest. You're looking at a year in jail. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you're stuck with this until you complete it or you get revoked. You understand? Shh. How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold it for 15 months. Do well. Done. 7.5 months. All right. Good luck. Banner. What do you do? What do you do? Say it again.
He's working full time.
Okay. What do you do for a living?
Deliver fine.
Okay. How many kids you got?
So.
Okay. Reduce the fees. Yeah. I'm trying to find out. So I'm going to reduce the fees so you don't have to just pay a ton of money for supervision and stuff. My concern is more that you get the classes done, learn from this, so you don't end up with a felony, you know?
Yes, sir.
All right. Good luck, friend. Please. Thank you, Mr. D. Roll it.
And here is one that cuts right to the question of what a courtroom owes a teenager. Today, a 17-year-old boy stood before the judge with his mother waiting outside and his little sister beside her. He was seen on surveillance video throwing an AR pistol, no serial number, after running from officers who responded to gunshots in a residential neighborhood. He admitted he saw the emergency lights and ran. He is in high school. His lawyer came from upstairs where she had been fighting a felony charge on his behalf. So here is the question. Texas law allows 17-year-olds to be prosecuted as adults in misdemeanor court. But when a teenager is seen on camera throwing a ghost gun, a weapon with no serial number, untraceable, illegal, and the charging decisions still leave serious legal questions about what can actually be proven against him individually, does the system's rush to hold him accountable as an adult serve justice, or does it serve speed? And when the judge says, stay in school, don't smoke weed, come back in 45 days, is that the right response to a 17-year-old with a ghost gun? Or is it the only response the system has left? The judge tested him in 45 days. He gave him conditions. He told his lawyer, make good decisions. That is what this courthouse does. It draws a line and dares the young man standing in front of it to step to the right side of it.
Roll it. Wait it. If you pick up a fourth case, holy moly, I'm going to absolutely lose it. Do you understand? I want my community safe. When you're out there, you need to make the right decisions before you do something. Think, if I do this, what's going to happen? If I say this, what's going to happen? And if it could lead to a bad result, then don't do it. Do you understand? Can you run his license to see, does he have a valid lawyer on it? Okay. You're not allowed to drive unless you have liability insurance as well. Do you understand? If you don't have car insurance, you cannot drive as well at all until you have a license and car insurance. Do you understand? Okay. Do we have any conditions, on the terroristic threat?
I got assigned to him, he was already in the back.
Correct.
So I don't know if there was anything with the previous case. I know one of them is against the brother. My understanding is, I think.
So I guess tell me about it, Alex, please, on both terroristic threats. Who are they?
Terroristic threats? Yes, Judge. So on the first terroristic threat, the complainant and the defendant are brothers dispatched to a residence in regard to a family disturbance. The defendant was removing the complainant's belongings from the residence and putting them in the back of his own vehicle to prevent the complainant from getting his things. The complainant tried to remove his things from the vehicle, and the defendant stated, "I will kill you." The complainant was in fear for his life when the defendant said this, and the defendant also later texted the complainant that if he touched his things again, he would cause him severe pain.
This is the second one.
And the second terroristic threat occurred on October 26, 2024, when the officer was dispatched to a Crunch Fitness. The officer made contact with the complainant, a manager at the gym, who stated the defendant was involved in verbal and physical altercations with other members of the gym, and multiple complaints were filed. The complainant stated the defendant's membership was canceled due to issues with other members and the defendant making threats. The defendant then continued to act aggressively after finding out this information and caused a disturbance by screaming and cursing loudly. The complainant told the defendant he needed to leave and not return. The defendant became more agitated, left the business, returned multiple times, and when the complainant stepped out with the defendant and told the defendant not to return, the defendant responded multiple times he was going to come back to the business and kill the complainant.
Judge, I would argue on that one. I'm gonna come back. I don't see an immediate threat or anything like that, any brandishing of anything or.
You're on, it's the going to that we.
They say, repeat what the threat was again?
He responded multiple times he was going to come back to the business and kill the complainant.
I'm gonna come back, you know, I think that there's enough to go forward. Don't go back to these places. I don't want you to have contact with either of the complaining witnesses. Do you understand? I'm gonna have you sign these bond conditions, make better decisions when you're out there, Mr. Jenkins. At some point, someone is gonna stop bonding you out and you will be stuck like Chuck in there until these things are over with. And it's gonna be a long time. Do you understand? You've asked me to give you a different lawyer. This isn't Burger King where you get your way. I will not give you another one. If you're unable to get along with Mr. Perez, then probably not him. Do you understand?
Yes, sir.
He may tell you things just because you don't like it. It doesn't give you a cause to complain and I don't like this person. No, he's going to give it to you. I've worked with him for many, many years. I trust him. He does a good job. That's why we gave him to you. You understand? Okay. So we'll have you sign these bond conditions and after that you'll be free to go. So he was not, I guess, having a good time with the prior lawyer.
Sure.
So,
I've spoken with his mom already over the weekend.
okay.
We had a really good talk about what was going on. I didn't know if she was gonna bond him out as soon as she did, so we're about to go have to talk to the factory about it.
My guess is though, is that if it's mom, she's not going to continue to do it because every time she bonds you out, all you're doing is you're giving free money to bonding companies. When you pick up new cases, all you're doing is you're giving money away. And I'm sure your mom doesn't have unlimited funds to just keep putting money away. Get a clue. What do you do for a living?
I worked for Uber because the job I was doing.
No, I just want to know, are you fully employed?
No, not at the moment.
You need to get a job. You have too much time on your hands and you become self-destructive.
It's hard to get a job because of my record.
Just listen to people.
Did she tell you something? Do you think it gets easier in life? No. You don't even have convictions and it's hard for you to find a job. How hard do you think it's going to be if they end up in convictions? Do you see my point?
Sure.
Make better decisions. 95% people are in there because no self-control. All right, Matt.
And Your Honor, on both the terroristic threat cases, there are previous conditions for.
The security sign on mission for terrorist threat in November, but I'm gonna get the reckless travel going during this time right now.
Okay. Is it, how do I pronounce your first name? See, Nia? Okay. Ms. Barrett, you're charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer spoke with the complainant at Spring High School in Harris County, Texas, and the officer retrieved a video footage of the event. The video showed the defendant turn to the camera stating ready, and then began striking the complainant multiple times with a closed fist to her head and face as the complainant falls to the ground. The complainant stated she felt pain and showed multiple signs of redness on her face.
Okay, it's in the actual high school, huh?
Yes, Judge.
Okay. Ms. Barrett, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand?
That was, I don't.
I want you to listen because these are your bond conditions. If you violate these conditions, I'm going to put you in jail. I'm also ordering you not to be in possession of weapons as well. Do you understand? Do you have a lawyer today? Would you like me to appoint you a lawyer? Okay. Can you file those conditions, please, Alex? Okay. So what I need you to do, ma'am, is, are you 17, 18? You're 20? Are you actually in high school?
High school?
Are you, you don't go to this high school, right?
So I have.
Stop. I'm only asking you. Then you're not to go back to this high school. Do you understand? All right, so I need you to fill out an application for me. Debbie's going to give you an application, and then I'll have you talk to a lawyer here momentarily. Do not leave until you sign our bond conditions, all right? Oh, please. Okay. Hey, what's up? Hey,
Morning, Your
hi,
Honor.
how are you?
I'm here on Miss Delaney Ibarra.
The last,
Ibarra.
Ibarra, okay. What's the word?
So, I guess first for bond, she has no bond set in this case because she was on no bond for the felonies last time we were here. But the state is unopposed to a PR bond in this case because
She's, whoa. She's being held at no bond on the upstairs.
I know, and
So-
the felony attorney is working on that. They resolved the felonies on Friday. And
They
the
resolved-
bond was not relitigated up there.
She's
I'm
going
just
into a
on the
PTI. She's going into like a like a 1-year PTI upstairs. And as part of that deal, we're gonna get rid of our misdemeanor, but obviously she needs to get out, in order to get into the PTI and everything.
The felony attorney knows about the bond issue. I don't know when she plans to address it, but I'm just here to get her out on the misdemeanor.
Since it's gonna be dismissed one way or the other, with the felony PTI. So I just wanna make sure that, our case isn't, holding up the felony offer essentially.
Is she here now? Do we
Yeah,
have
she's
her?
in the holding cell
Do
here.
you mind bringing her out? I mean, they don't even have a date set upstairs though.
That's
It's set for
I know, and
126.
I've spoken to the felony attorney. It was a misstep on her part for sure, but I spoke to the felony attorney and she will go approach on it at some point. I mean,
Are you anticipating a PR bond upstairs too?
I would assume so, yes, because she has a PTI, like the felonies have been resolved, so I would assume,
Never
yes.
assume anything,
I
you
know,
know?
I know, and I can't speak for what happens in the felonies. I'm only on the misdemeanor, Your Honor, but,
And I just see that the agreement's is in deeds and everything, so.
Yeah.
It looks like we're moving towards that.
yeah.
I just wanna make sure that we don't.
When do you want to set it for? So maybe like a week
Yeah, that's fine.
and we'll see. Okay.
That's fine.
Does she have history of like flight? Do you know? Because she's got
She has
two.
no history of flight. She lived in Houston most of her life. She is pregnant right now. She's 6 months pregnant, and essentially, we just kind of want to
She
get
has
her
two
out.
prior assault cases. Both of those, any flight in respect to those cases?
I'm not, I actually ran over here.
I don't think, so. Based on what district clerk shows, no, Your Honor.
Let's take a look. I don't see.
All right, go ahead and sign.
So she only has one prior assault. It looks like that one was dismissed. And this new one here, looks like it was charged assault of a hospital personnel, right?
Yeah, that got dismissed on Friday.
Did they refile it as? Okay.
It just got plain dismissed, and then the PTI is for the assault on a public servant, I think. It's a mental health case, Your Honor.
I'm down with you. I'll grant you a PR bond.
Okay, thank you.
The only thing I'm going to ask is that she stays in touch with you, right?
Yes.
I'm not going to continue to do this. Like if she gets out, she just takes off. I'm not going to do it again,
Yes.
and I'll admonish her
understand.
as such. So,
Thank you, Your Honor. I guess she'll still come out, right?
yeah, I need to admonish her.
Yeah.
Who is our CW?
CW,
Hold on a second. We'll get there.
yeah.
Colin,
Mr.
tell me what you got.
I have Sarah Castillo, Judge.
Okay.
That's the one where we were trying to get the records from the sheriff's office. They finally got them to me. And
You have everything you want?
I haven't been able to get through it all. It's like almost 600 pages.
Second. I didn't thought it was going to be long. Okay. Gabe. Blossom. Do you speak English, man?
Yes, sir. Yes, Your Honor.
You see, Bar, I want you to understand and appreciate that you have a lot of lawyers that are going to bat for you now. trying to help you even get out. Your lawyer here is asking for a PR bond. You even have the state that's in agreement to get you a PR bond. The only thing that we're asking you to do is be safe to our community. Don't pick up any new cases and stay in contact with your lawyer. Right now, I'm going to grant you a PR bond, but I'm not going to do this over and over and over and over and over. I'm going to give you one chance to get out there and do the right thing, make the best of the chance that you're giving. But if you get out there and you just take off and you don't stay in contact with anyone and you pick up a new case, all bets off. Do you understand?
Yes, Your Honor.
I'm not asking for much. All I want is my community to be safe and for you to stay in contact with counsel. That's it. Okay, so I'll grant you the PR bond. Looks like the bond is already set. We're going to set it out for a week because you're still at no bond upstairs, so we don't know what's going to happen in your felony case. So we'll set it off for a week, and then we'll go from there. Okay?
Yes, Your Honor.
Do you have any questions?
Yes, Your Honor.
So tell me about this one here. Who's the complaining witness?
Dating relationship, boyfriend.
Okay. Does he want to have contact with her?
He's not, we haven't really been, he hasn't been cooperative with, so I wouldn't be able to tell you what he wants other than to drop charges, really.
So I want you to understand that I am going to grant what's called a magistrate's order for emergency protection that identifies Mr. Rodriguez as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior, and you cannot be in possession of a weapon. Do you understand?
Yes, Your Honor.
I'll take off the residential restriction just in case, but everything in the MOAP is stuff she shouldn't do anyways. All right, understand.
Yes, Your Honor. Thanks.
Judge, I just had a quick question. We're set for trial tomorrow in ERD on a family violence case. And I just wanted to know logistics wise, would we pick tomorrow and then start Wednesday? Or if we have a jury tomorrow,
Are you really going to go?
I mean, it sounds like we're gonna go.
You hear this? I've got 7 other cases set for trial as well tomorrow in here.
Okay.
So let's see which one actually
Yeah, let's see
goes.
what the trial
So,
goes.
but technically we pick on a Tuesday, everything starts testimony on a Wednesday, and then we go. That's the way. So, yes, thank you. Hi, Colin.
And this one goes right to the foundation of American criminal law. Today, a judge found no probable cause on a charge of engaging in organized criminal activity. The facts: a U-Haul was stolen. Officers arrived. One of the co-defendants ran. 2 others, including this defendant, remained in the U-Haul. The charge was organized criminal activity, one of the most serious misdemeanor charges this court can see. The defense lawyer stood up and made one argument: mere presence is not enough. Texas law says so. The judge looked at the record. He agreed. So here is the question. Organized criminal activity requires proof that a defendant intended to establish, maintain, or participate in a criminal combination, not just that they were present when it happened. When prosecutors charge someone with engaging in organized criminal activity based primarily on being in a vehicle with others who committed a crime, are they applying the law correctly? Or are they using a serious charge as a pressure tool, knowing that most defendants will plead rather than fight it? The judge said, "I'll find no probable cause for now. If you find something later, come back. That is not a pass. That is a standard." And today the standard held.
Hi, Colin.
Judge, I have 3 appointments, 2 out on bond, 1 in custody.
Okay, who do you want to talk about?
Bond, I just wanted to see if I could revisit. Not really revisit, just kind of modify the bond conditions slightly.
Absolutely. Who are you talking about?
The first one is Mr. Perez, Judge. Jose Perez.
This is a DWI.
Yes, sir.
Okay.
I understand that he lives in Dallas, Judge, and he was wondering if he could do the UA somewhere over there.
So what'll happen is, Perez, come up. Oh, Blasi, you're still here. Wonderful. Yay. I don't care where you live. I don't care what you do. You were still under bond condition of this court. If you do not have a Texas driver license and if you do not have liability insurance, you are not allowed to drive. Do you understand?
I haven't driven.
I am also ordering you not to consume alcohol or illegal drugs. If you get called upon to take a test You must go to a Quest Diagnostics in Dallas, take a test there, and get the result to your lawyer. It is on you to do that. Typically, when we have someone that does it here, they come into here to downtown and they take a test and I pay for it. But because you're over there, I cannot pay for it. You will be required to foot the bill on that. If you fail to go test when you're called upon, I will issue a warrant for your arrest. There are no more PR bonds. You pick up a new case, you violate any of these conditions. Do you understand? One more thing. I don't know what your immigration status is, but if you go to jail and you're not in this country with permission and you spend any more than 46 hours in custody, you will probably get an immigration detainer and it's not going to go well. So if you're not in this country with permission, you better live like you have a halo over your head. You understand? All right. Good luck. Thanks.
And the next one, Your Honor, is sort of.
Just take a seat.
He's also just asking that if he can change the location of his UAs. And I wonder if I could just speak to
Where does he live?
that. In Pasadena, Judge, it seems like
No.
somewhere in South Houston. He said, okay.
Still under bond condition of this court, still required. If some time passes and then he's good, then we can perhaps modify. But this is the beginning of the case. I want to make sure that he's not using it. I don't know him. I've never met him. And so, right, I'm just doing everything that I would do to every single other person. Yeah.
Excellent. Thank you, Judge.
Absolutely.
The last one, Your Honor, is Mr. Francisco Cerda. He's in custody, Judge, and I wonder if such a problem conferences.
Is that C or an S?
The C, Judge, the RDA. Oh, he's right here.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
Judge, that's my concern. If you may, I want to bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
and Your Honor,
can you just, does mere presence impute criminality?
No, Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have at this time.
But I'm not going to sit here and hold someone.
And that's why we defer to the court.
Let's look at what the statute says, because, you know. 7102.
No. Magistrate. There's no information given for this defendant at all. And we have no OR. So just, that's the refile.
You looking?
Yes, that's great.
A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so and call the witness.
He's in custody, and I can't. I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, and the compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure.
Johnson.
Mr. Ewing. Hey, good morning. Good morning, Mr. Ortega.
Good morning.
So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 81 days in jail, credit for the 81 days that you've done. You need to understand that this will reflect now as a conviction on your record. It's going to be there for the rest of your life. From now on, any new misdemeanors that you pick up, you will be facing a minimum of 30 days in jail. You understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to test on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this or undo this. Is this what you want to do?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty? How do you plead to the offense? Guilty or not guilty?
Oh, I already know.
I'll find you guilty. I see that you got a probation upstairs. Let me say that you're very lucky that you got one with the type of cases that you have. Felony probation is no joke, so don't take it as a joke. You're young, you're still held to a high standard, and you're expected to complete everything you don't. If you go on, you use drugs, you pick up a new case, You could be very well spending a lot of time in prison. You've been given a chance. Make the most of it. You understand? All right. You ever need any help? All you got to do is come back here. Anything you need, cell phones, tablets, food, jobs, we can give you anything that you need. All you got to do is come back and ask. All right? All right, man. Good luck.
Thank you, Judge.
Thanks. We have here.
Leonardo Gomez.
Good morning, Mr. Gomez. Shh. Mr. Gomez, you are charged with driving while intoxicated. First offense. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. I'm sorry, state, I forgot to grab you. My fault, I forgot to grab you.
Quiet for the interpreter, please.
You have been offered 15 days in jail with credit for the 5 days that you've done. You need to understand that this will reflect as a conviction on your record today and forever. From now on, any new cases that you pick up here, you will be facing a minimum of 90 days in jail. Are we going forward with the enhancement on the 15 or not?
It's gonna be a bad.
Are you sure?
Oh, I'm sorry. Yes, it's not true.
Right. Is it true or untrue that you had a 0.15 or above, Mr. Gomez?
It's true.
Is it true to the enhancement? So understand, that's what makes it a Class A misdemeanor. So from now on, because this is going on your record, if you ever get charged with a future one, you'll be looking at a minimum of 90 days in jail. You give up a lot of rights by entering into this agreement and this plea bargain agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Is this what you want to do?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'll find you guilty, sentence you to the agreement. I am going to suspend your driver license or the ability to drive for 90 days. Do not drive until you get a license, and good luck to you, sir. You stand.
Hi. Hey, good morning, Judge. I got two new cases.
Welcome back to Judge Fleischer's courtroom. And today's docket was exactly the kind of day that reminds you what this place is really doing. A man with 3 open cases, threats to his brother, threats to a gym manager, and now reckless driving, came back demanding a different lawyer. The judge said no. He said, he will tell you things you do not like. That is the job. That does not make him the wrong lawyer. That makes him the right one. A 17-year-old with his mother and little sister waiting outside walked up to the bench after being seen on camera throwing an untraceable ghost gun. His lawyer was fighting the case on 2 fronts. The judge told him, stay in school, stop smoking weed, come back in 45 days. His mother was in the hallway. He walked back out to her. A charge of organized criminal activity was thrown out before it started because a defense attorney stood up and said 3 words, mere presence isn't enough. The judge looked at the record. He agreed. The man walked out with an immigration hold still on him, but without a charge that could not be proven. A man on 3 open terroristic threat cases got his bond conditions signed and was told, when you're out there and you think about doing something, ask yourself what's going to happen next. Then don't do it. A woman charged with stealing from a Walmart was told the store ban is a condition of her bond. A delivery driver asked for a referral to a trade. A 28-year-old who stole boots and a jacket from J.C. Penney heard from a judge in another city that stealing clothes at 28 is not stealing bread to feed your children. It is bad character, and your son is watching. Every one of these people walked through the same door today. Some of them heard something that might actually stick. Most of them will go home and try to figure out what comes next. A few of them will be back. This courthouse does not give up on people. It gives them conditions, curfews, monitors, drug tests, lawyers, and time. What it cannot give them is the willingness to use any of it. That part is entirely theirs. We will see you in the next one.